All rise. Oh yay, oh yay, oh yay. This Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court. Please be seated.
We have two cases this morning. In just a moment, Mr. Hivner is going to call the cases out. I will remind you that you have 30 minutes per side. If appellant wishes to reserve rebuttal time, please let us know that before you begin your argument. Any preliminary matters, Mr. Hivner?
I know, Your Honor.
All right. Mr. Jim Hivner, our clerk, please call out the first case.
James Williams versus Smyrna Residential LLC et al.
May it please the court, good morning. I'm Christy Kreider of the Nashville Bar, and I'm here on behalf of the appellant, Azalea Court. Your Honor, I would like to reserve 5 minutes for rebuttal, please. On behalf of Azalea Court, I ask that this court overturn the finding of the Court of Appeals and first find that a validly appointed power of attorney vested with the broad powers by her principal, to make decisions about claims and litigation will not be stripped of that authority simply because the arbitration agreement that she entered into on her principal's behalf was with an assisted living community. And second, further reverse the Court of Appeals and hold that the wrongful death beneficiary's claims are derivative of the estate's and therefore are bound to the same arbitration agreement that the decedent would be if he were living. The facts briefly are that Mr. Williams' estate brought a wrongful death action against Azalea Court, an assisted living facility. As part of that action, Azalea Court filed a motion to compel arbitration. The trial court denied that motion to compel arbitration, finding first that Mrs. Sams, Mr. Williams' daughter and duly appointed general power of attorney, did not have the authority to enter into the arbitration agreement on his behalf. The trial court found second that even if Ms. Sams had that authority, the wrongful death beneficiaries were not bound to the arbitration agreement that the estate was bound to, and therefore refused to enforce the arbitration agreement. The Court of Appeals affirmed the trial court, and this court granted the Rule 11 application on 5 different questions. The facts that are relevant to this appeal are that first, in 2007, Mr. Williams gave his daughter his general power of attorney. And in that document, he specifically gave her the authority to make all decisions about claims and litigation.
Ms. Carter, what language in that power of attorney authorized Ms. Sams to make a health care decision?
There was no language in that power of attorney, Your Honor, that authorized Ms. Sams to make a health care decision.
And in Owens, didn't we hold that admission to a nursing home is a health care decision?
In Owens, Your Honor, this court held that admission to a nursing home is a hybrid, both legal and healthcare decision. And what is important about the Owens decision, Your Honor, is that it found that the arbitration agreement was at its heart a legal decision, and the court used that language, which also had a healthcare component, and not vice versa. And the court in Owens never held that this court was suggesting that a general power of attorney, given the authority by her principal, entrusted by her principal, to enter into an arbitration agreement should be stripped of that authority that her principal gave her simply because she was entering into it with a long-term care provider. I'm sorry, go ahead.
So you're saying that if one child had the general durable power of attorney and one had the health care power of attorney, either one of them could enter into an arbitration agreement?
That's correct, Your Honor, because under this Owens decision, this court's decision in Owens, this court found that it was a hybrid, and although that it was a legal decision at its heart, it was going to extend the authority to enter into that arbitration agreement also to a healthcare decision maker. And the court's stated purpose in that decision for extending what would be at its heart a legal decision to a healthcare decision maker is that it wanted to increase access, the ability to secure services for your principal rather than to limit it. And the court specifically stated and used the word uncertainty. We want to remove uncertainty from this process. And this court said, we are not going to be in the business. Courts are not going to be in the business of trying to carve out small pieces of a contract for admission to a nursing home and say some of those are legal decisions and some of those are healthcare decisions, and we're going to pick and choose who is part of that transaction can make which decision. And to Your Honor's concern about the healthcare decision-making piece of this, also in 2007, this principal, Mr. Williams, invested in his daughter the authority to make healthcare decisions as well through his living will in 2007.
Not exactly, because the living will talked about, do not resuscitate, nourishment, that sort of thing. It's a real stretch to say that living will authorized a healthcare decision, such as an admission to a nursing home or signing an arbitration agreement, isn't it?
Your Honor, in that document, you're correct that Mr. Williams first chose what he would like his end-of-life healthcare decisions to be with regard to CPR and those sorts of things. But he also, in that document, decided that he wanted to entrust his daughter, Miss Sams, to act as his surrogate, and that was the word that he used, to carry out those end-of-life care decisions.
End-of-life care. So how is a nursing home admission an end-of-life decision?
Well, Your Honor, you're raising the very question that was raised by the Court of Appeals in this case.
And if she was using the living will as her authority to act, why doesn't it show when she signed it, she was signing as, I don't even know what the word would be, a living will person or whatever? I mean, that's just...
a healthcare agent, I think, has a surrogate.
That doesn't even exist.
She wrote the three letters POA on the arbitration agreement for her authority.
Living will, did she?
No, she didn't, because what that document shows, what the general POA shows, is that Miss Sams, when she was entering to make the decisions for her principal about contracting to move him into the assisted living community, she understood, pursuant to that, as evidenced by her writing POA on that document, that she was acting pursuant to the POA. And your concern that you raise is the concern that was raised by the Court of Appeals.
But counsel, let me ask you, why isn't this, at the end of the day, a statutory interpretation question of the Durable Power of Attorney for Healthcare Act, which lays out in excruciating detail the components that need to be present in a power of attorney used to make healthcare decisions. You've said it's undisputed this power of attorney did not meet those requirements. What you're asking us to do is to say that that is not applicable to this decision, and I'd like you to point me to some language in the Durable Power of Attorney for Healthcare Act that would permit us to interpret it that way.
Your Honor, there is nothing in the Power of Attorney for Healthcare Act that authorizes someone who has not been specifically given the authority to make healthcare decisions to make healthcare decisions. We will not find that language in the Act.
But you are asking us to exclude something. Owens had language in it to the effect that this is a hybrid decision. if it's a healthcare decision in whole or in part, why would we not be bound by that act?
Because, Your Honor, what we have here is different than what we had in Owens. In Owens, we had an 11-page, we had an extensive...
I'm more asking you about the language of the act.
Your Honor,
because
the
that's
language...
what we look to first.
Yes, the language of the act does not give this general power of attorney the authority to make a healthcare decision. It is not in that act.
Why is that not the end of the question?
Because this was not solely a healthcare decision. There is no need for this court to yoke a standalone, optional arbitration agreement, which no one in this case has disputed Ms. Sams had the authority to enter into. There is no reason for this court to yoke that with the separate decision she was making that day, which was
Except that the legislature apparently has.
The legislature has not. The only time in law that those two things have been yoked was the Owens decision.
So are you saying then that this decision on the arbitration agreement only is not a healthcare decision within the definition in the Durable Power of Attorney for Healthcare Act?
Yes, Your Honor, that is what I'm saying.
So you want us to overrule that holding in Owens?
No, Your Honor, Owens does not stand for the proposition that this is solely a healthcare decision. Owens stands for the proposition that this is at its heart a legal decision.
Let me follow up on that, because I took the earlier discussion that I think you were having with Chief Justice Page to mean that your position does not turn on the fact that in this case, the arbitration agreement was not a condition of admission. You seem to be taking a pretty broad view of, attorney-in-fact's authority to enter into an arbitration agreement and framing that as a legal decision always, which may sometimes also be a healthcare decision, but fundamentally is a legal decision. But in this conversation with Justice Kirby, I take you to be saying that perhaps it does turn on whether it is a condition of admission to the facility or not. So can you just, I guess, articulate what your position is? Should we decide this case based on the fact that it was not a condition of admission, or are you asking us to hold more broadly and perhaps to even overrule, in part at least, Owens to make clear that the power to enter into an arbitration agreement always exists when you have a general power of attorney and may only sometimes exist when you have a healthcare power of attorney?
Your Honor, you are correct. First and foremost, this court does not need to yoke this standalone optional arbitration agreement that Ms. Sams had been vested with the authority from her principal to enter into with the separate contract that she was executing to enter him into the building, signing the lease, agreeing to the terms of the lease, what extent of services would be provided. Those two things do not need to be yoked.
Well, but didn't the nursing home yoke them together when she sat down at that admissions table and they said, "Here, sign this packet of paperwork"?
They did not yoke them.
Have her sign the admissions form and then come back in a month later and say, "Would you like to sign this standalone arbitration agreement?" I mean, no, they yoked them together at the inception of this, didn't they?
They were executed on the same day. We know that from the record.
Right.
We also know from the record that they were not yoked because we know that one was a condition of admission, which is that you have to enter into the contract with us, the residency agreement, and the other was not. And so if Ms. Sams had decided that she did not want to elect arbitration forum, then she would have been permitted to decline. And so those were not yoked. And to the second part of your question, Justice Campbell, even if this court determined that it was going to analyze this under Owens, even though Owens was a totally different set of facts, what's so important to remember about Owens is that the arbitration agreement was mandatory and it was embedded on page 11 of the admissions contract, the larger agreement. So that, Justice Lee, is really the definition of them being yoked, because they were in the same document and they were both required for admission. And even in Owens, the court said that is at its heart a legal decision. It never said we are stripping a legal decision maker of the right to make that decision. It simply said we are going to also extend that. And why were they going to extend it? Why was this court going to extend it to healthcare decision makers? Their articulated reason was to help increase accessibility for Tennesseans to gaining services.
Let me
not to
point you,
restrict it.
I want to point you to a statute, so 346108. This is just the attorney in fact, kind of the general attorney in fact statute. And that statute has a provision that sort of carves out certain decisions from a general power of attorney. So you can do these things and then you can't do these things. And one of the things that you can't do, if just with a general power of attorney is, and I'm at subsection 9 here, I guess C9, make any decisions regarding medical treatments or health care except as incidental to decisions regarding property and finances. So I guess in the situation in Owens, where it is part of the admission to the facility, is it your position that decision regarding medical treatments or health care, such that it would be carved out of the general power of attorney?
If we get to the second part of the analysis, if this court decides it need not yoke them because this was optional and not a part of the contract, then we don't get there. But if this court decides it is required to yoke the independent arbitration agreement that was voluntary with the larger healthcare contract that was entered into that day for healthcare services, what the Owens court said is that that decision is still at its heart a legal decision.
But it's also a healthcare decision in that context.
It has a component of a healthcare decision, but the court found it was a hybrid of both. And if the court is extending the authority of a healthcare decision maker to make a legal decision for the stated purpose of increasing accessibility to obtaining services, then there is no reason that the converse should not be true, which is that a person vested by her principal to make both legal decisions and also trusted by her principal to make and carry out his critical end-of-life healthcare decisions, that this court should somehow carve out that very narrow space between those two trusted pieces of authority and find that this arbitration agreement, which was optional, somehow falls into that tiny sliver where we are going to strip her of the authority to make both the legal decision to enter into arbitration agreements that her principal had given her, but also to not recognize that he also entrusted her with end-of-life healthcare decisions. And as Justice Lee pointed out, we are not arguing to this court that that living will that gave her the authority to make trusted end-of-life healthcare decisions, that this arbitration agreement somehow fell within that. It doesn't.
It sounds like you're making that argument because you keep talking about the living will and end-of-life decisions. What does that have to do with this then?
It has to do with effectuating the plain intent of this principle for what authority he wanted to give her.
And it is in the power of attorney. What exact language in this power of attorney do you rely on who authorizes her to sign the nursing home admission agreement?
It gives her the authority to make all, and it doesn't say some decisions about claims and litigation. It doesn't say only decisions about claims and litigation that are with someone other than a healthcare provider.
What does it say? To bring claims and litigation?
To handle all, to act for me in all claims and litigation matters.
So what about an arbitration agreement is a claim?
An arbitration agreement
Is an arbitration agreement a claim?
Your Honor, yes, it is.
It's a claim.
The arbitration agreement is the contract through which...
A claim for what? An arbitration agreement is a claim for what?
It is not a claim itself.
Okay.
It is making a decision. It is the two parties agreeing that if we have a claim, we are deciding,
But that's not bringing a claim, is it?
it says to act for me in all claims.
Okay, so
And
is an arbitration agreement a claim? Yes or no?
the arbitration contract itself is not a claim.
Okay, is it a litigation? Is an arbitration agreement a litigation?
An arbitration agreement is not litigation.
Okay, so if you're authorized to handle claim and litigation, and neither of those, and an arbitration agreement is not either one of those, then what authority is there at all under this power of attorney to sign an arbitration agreement? You're stuck with the language of the power of attorney, and you can't extend it. Or can you? Or are you saying you should be able to?
I don't think it requires an extension. I think that Mr. Williams, when he gave Miss Sams, his daughter, the right to act for him in all claims and litigation matters, that would include her making a decision about where the claim would be brought. That is part and parcel of giving the authority.
Really a claim at that time she signed it, though, was there?
Well, it was not that she was only giving it to her for that one moment in 2007. He chose that he wanted that to continue, including wanting to continue past the period where he had mental capacity, which is what happened in this case.
Counsel, can I bring you back to the Durable Power of Attorney for Healthcare Act? I understand your argument that this is really essentially a legal decision. It was not her, the admission into the facility was not conditioned on it. But the gist of the Durable Power of Attorney for Healthcare Act is that if the subject matter of the decision is healthcare, it is governed by the Act. It doesn't say, it doesn't talk about what kind of decision it is, whether it's legal, whether it's something else. It is clearly aimed at any decision that is made in the context of healthcare. I don't understand how, under this act, we are not bound by the legislature's decision to say that if decisions on the subject matter of healthcare are being made, this is what the power of attorney must have. That's what I'd like to hear you address. The fact that it's optional, the fact that the kind of decision is a legal decision, none of that. I don't find any language in the Durable Power of Attorney for Healthcare Act that would allow us to ignore the subject matter of the decision. And I'd like to hear you address that concern.
Your Honor, pursuant to the general power of attorney, Ms. Sams had the authority to make decisions about all claims and litigation matters. And if we are looking at the intent of the principle here in giving that authority.
You understand that I'm more looking at the intent of the legislature. That's what I'd like for you to address.
Your Honor, I don't think that there is anything in the Durable Power of Attorney for Healthcare Act that mandates that this court strip the agent of authority given to her by her principal simply because the party that she is entering into that contract for about claims and litigation is a healthcare provider. And in fact, the United States Supreme Court addressed a very similar analysis to this in Kindred versus Clark in 2017. And in that case, the Kentucky Supreme Court was also evaluating an arbitration agreement between a nursing home in that case and its resident. And in that case, the Kentucky Supreme Court refused to enforce the arbitration agreement. That case, the plaintiff held a general durable power of attorney very similar to this one. And the United States Supreme Court overturned the Kentucky Supreme Court in that decision, finding that the Kentucky Supreme Court could not apply a principle of state law, which in that case was the clear statement rule. And in this case, Your Honor, your application of the healthcare power of attorney statute would bear a similar analysis and take one category of arbitration agreements, and that be any arbitration agreement ever entered into with a healthcare provider.
Are you asking us then to hold that the Durable Power of Attorney for Healthcare Act is unconstitutional?
I am not, Your Honor. What I'm asking the court to do, what
That
Azalea...
it's preempted? What, I mean, is that the preemption argument? I'm more want, first I want to focus on the act itself. Then we can move to, whether it conflicts with the federal act, all that sort of thing. I have not heard you give me anything in the language of the act that goes to the legislature's intent that it not be applied to a legal decision where the subject matter is health care.
Maybe I can, and I'm interested in this question too, so I just want to point you specifically to 34.6201 subsection 3, which defines healthcare decision. Can you just explain, whether the arbitration agreement in this case fits in that definition of healthcare decision?
The arbitration agreement in this case does not, because it was separate from the contracting for healthcare. It was a totally separate, standalone agreement with the assisted living community that provided that if a dispute arose between them, that dispute would be handled in the forum of arbitration.
So it's your position that because it was not, because admission to the facility was not conditioned on this agreement, it does not constitute consent to healthcare.
Correct.
So is your answer to that question different if admission is conditioned on signing the arbitration agreement? Would you concede that in that situation, it falls within the definition of healthcare decision? And I realize that's not this case, but I'm interested in your answer to that question.
Your Honor, the answer to that question is that the Owens Court warned us against going down that slippery slope, because the court said we don't want courts to have to be in the business of slicing out little parts of each of these contracts and determining which is healthcare and which is legal. Certainly the situation that Your Honor just articulated would be one more step down that path that makes more sense than the case that's before the court today. Because if the court decides to yoke those two decisions together, meaning a mandatory arbitration agreement in order to gain access to healthcare services, that certainly looks more like it has a healthcare component than one where they are not yoked at all, where it is totally optional. But that's a path that this court encouraged us not to go down in Owens. And with the, am I over? I am over.
Go ahead and finish your
Oh, that's okay. Thank you, Your Honor.
Good morning, Your Honors. May it please the court. My name is Sarah Martin, and I represent the plaintiff in this matter and the appellee in this case, Mr. James Williams. Mr. Williams filed this lawsuit against Azalea Court over the wrongful death of his father, Granville Williams. The issue here is where the plaintiff may litigate these claims. This court should affirm the decision of the trial court and court of appeals for two reasons. First, the trial court and court of appeals correctly determined that Karen Sams, the plaintiff's sister, had no authority to make the decedent's health care decisions, including the decision to admit him to Azalea Court, and thus she had no authority to sign an arbitration agreement in the course of that admission. And second, the trial court and court of appeals correctly determined that the plaintiff, a wrongful death beneficiary who was not party to the arbitration agreement, is not bound by it in prosecuting this action.
Ms. Martin, do we have to determine that this is a health care decision in order to rule in your favor?
There are two issues in this case, but as to the first issue, yes, Your Honor, I believe so. The defendants also argue for the very first time on appeal that the living will and the post or the physician orders for scope of treatment together meant that Mr. or Ms. Sams was a healthcare surrogate under the Healthcare Decisions Act as well. And the plaintiff has argued that that argument was waived before the Court of Appeals and also before this court. And so I just sort of want to address that first, because that sort of narrows the scope of the case and the appeal. And so defendants, just to be clear, never uttered the word surrogate, never uttered the words Healthcare Decisions Act, nor did they mention the statute in their briefings. And as a result, the plaintiff did not have a full and fair opportunity to seek discovery on, much less fully litigate that issue. And so because there's no healthcare authority and because all the parties agree that the durable power of attorney did not include any authority to make healthcare decisions, then this becomes a narrower issue, right, of whether that power of attorney instrument conferred the right to somehow enter into this arbitration agreement because it can somehow be divorced from the rest of the admission.
Can you explain how the arbitration agreement in this case fits within the statutory definition of healthcare decision?
Your Honor, under this court's decision in Owens, this court determined that an arbitration agreement in the healthcare context.
Well, the arbitration agreement in Owens was a condition of admission to the facility, right?
It was, Your Honor, and this,
so I want you to look at, I guess, the statutory text itself in the Durable Healthcare Power of Attorney Act, and tell me how. So, setting aside Owens, how does the arbitration agreement in this case, which was not a condition of admission to the facility, fit within that statutory definition?
So in this case, there wasn't just an arbitration agreement, of course. There was also the full admissions agreement, which the defendants argue was mandatory. The defendants also, interestingly, somehow argue that the power of attorney conferred some authority to be able to enter into the admissions agreement as well, although it wasn't discussed up here. The admissions agreement is several different pieces of forms, documents, Residents' Rights Act things. All of those things are kind of embroiled in this one healthcare admission to this assisted living facility. Under Owens, this court was very concerned with parsing out what a person with healthcare power of attorney could do in terms of all of that paperwork. And it's important to note that this arbitration agreement, while it's consistently referred to as voluntary and a standalone agreement, was an attachment to the mandatory resident services agreement. And that's on page 8 and 9 of the defendant's reply, where they talk about, this, we don't want to strip this power from this attorney in fact. And so it's very important to note that also under all of the Medicare services rules and all of that sort of thing, the federal government has actually created rules that now a healthcare facility cannot condition admission on signing an arbitration agreement. So we probably will not see this anymore under the facts in Owens.
So I take it then that your position is that because this was kind of part of the process of admitting Mr. Williams to this facility, that it was, and I'm just looking at the actual language of the statute here, that it was consent to health care? Is that your position?
Yes, Your Honor. All of the admission documents cannot be divorced from each other in that context. It would be confusing for healthcare principals, it would be confusing for facilities, and what the defendant is really asking this court to do is say, we want to carve out this standalone agreement, which was an attachment to another agreement that was mandatory. We want to carve that out and say a person with legal authority for claims and litigation under a durable power of attorney could sign just that agreement, but not the other agreements. And that's just untenable. under this court's decision in Owens, regardless
And
of.
so if there, I mean, let's say there's, as part of the packet, admission packet to admit a loved one to a facility, there is a form that, authorizes a direct deduction from your checking account. Is it your position that would also be kind of part of consent to health care?
Yes, Your Honor, and it would be impossible to really admit people to nursing homes or assisted living facilities if that were not the case. Because then we're going to be looking at and analyzing every single document that was executed and saying, that's not exactly a healthcare decision. So this is.
So anything that's part of that admission packet
Yes, Your Honor.
would
That's the
fall
plaintiff's.
within the definition of healthcare decision.
Yes, Your Honor.
Such that someone who lacked a durable power of attorney for healthcare would lack authority to
That's-
make that decision.
That's correct, Your Honor, and that appears to be how the lower courts are interpreting that as well. The Court of Appeals in Bockelman had an agreement that didn't say explicitly that it was a healthcare decision. There have been situations where and I believe in Bockelman as well, it wasn't a mandatory agreement that admission to the facility was conditioned upon. And so the lower courts have been interpreting Owens in that manner, that this is a healthcare decision, it's consent to healthcare, all of these different kinds of documents and decisions are embroiled in that admission and can't be divorced from each other. Otherwise, we would have a lot of uncertainty in terms of what a durable healthcare power of attorney in fact could do.
So let me just make sure I fully understand your view on this. So are you familiar with Venn diagrams?
Yes.
Okay. So in your view, is there any overlap? Is there any area of overlap where there are certain decisions that could be made both by someone who has a durable power of attorney for healthcare and someone who has a durable power of attorney?
No, Your Honor. And
So it's totally separate in your view?
in the plaintiff's view, all of the decisions that are made in admitting someone to a nursing home are healthcare decisions. And that's because, as has already been talked about, the legislature has made a clear codified policy in section 34-6-203 and said, look, consent to healthcare decision. There can be no arbitration agreement without the admission.
Does it matter what type of condition the admittee is in? Because some of these facilities, basically, they live there and all they get is maybe some meals and recreation trips and that sort of thing. Others, they're almost 24-hour care.
It depends to the extent that we're dealing with capacity as an issue for that admission, because sometimes the patient or resident can admit themselves and sometimes they cannot. In this situation, allegedly, Mr. Williams could not. So Miss Sams, his daughter, admitted him instead. But the problem here is that Miss Sams either had to have healthcare authority for healthcare decisions under a durable healthcare power of attorney, or she needed to be his surrogate under the Healthcare Decisions Act, and we don't have either of these things here. And so that's the issue. And under section 34-6-203, an attorney, in fact, may not make healthcare decisions unless the written instrument specifically authorizes the attorney, in fact, to make healthcare decisions. That is an important, and this court must give full effect to that legislative intent in enacting that statute, and adopting the defendant's position simply will not accomplish that.
So it's your position that entering a facility of this type of any kind is always a healthcare decision?
Yes, Your Honor.
And that the arbitration agreement is essentially a mandatory part of that, regardless of what they say?
It's not that it's the admission is conditioned upon executing it, but it is a packet of paperwork that is presented to the resident or the resident's representative for admission to the healthcare facility. It makes utterly no sense, Your Honor, respectfully, that this arbitration agreement can be divorced from the admission, because if the admission did not occur, Neither did the arbitration agreement. There would be no claims to litigate if the admission did not occur. It simply doesn't make sense to not yoke those things together. And the defendants, they rely heavily on the Kindred case from the U.S. Supreme Court in 2017. But one thing that's important to note, so that was a consolidated case that went up to the Supreme Court. And it struck down Kentucky's clear statement rule that said, if you have a power of attorney document, you have to say specifically in that power of attorney document that you have permission, that this person has authority to enter into arbitration agreements explicitly. And the Supreme Court said, can't do that. That disfavors arbitration agreements. It puts them on unequal footing with other contracts, and we're not going to allow that. So we're not saying that a durable power of attorney can never enter into those agreements, but we are saying that you can't do that. So they kicked it back down to the Kentucky Supreme Court to determine if, without the clear statement rule, the power of attorney instrument was still broad enough to encompass that arbitration agreement. And guess what the Kentucky Supreme Court decided? It wasn't. And that's okay. That was proper, and just like the FAA doesn't preempt state law principles governing an unconscionability analysis, just like the FAA does not preempt state law principles governing how powers of attorney are interpreted, the FAA similarly does not preempt the policy that this court announced in Owens, which is that the execution of an arbitration agreement in that context is a healthcare decision. And importantly, too, I don't know what Kentucky's policy was in terms of durable healthcare powers of attorney, but the policy in Tennessee is clearly that the principal has to designate that authority very explicitly.
How does the Durable Power of Attorney for Healthcare Act interact with the statutes on just a uniform Durable Power of Attorney Act? I'm looking at 34.6.108C9, which I believe Justice Campbell referenced earlier, that says that nothing in this section on a regular durable power of attorney shall be construed to vest an attorney in fact with authority to make any decisions regarding medical treatments or health care.
Yes, Your Honor, and if I understand you correctly, that statute is to be read in pari materia with the health care.
We do need to read statutes together, and does that go to the Venn diagram question that Justice Campbell was asking, or not? I'm trying to sort that out.
It would be the plaintiff's position that that's just further evidence that the legislature is saying durable powers of attorney do not and should not be interpreted as including powers to make healthcare decisions. And then you go over to 34-6-203 and you look at that statute and you recognize that statute says, the legislature says, if you want your principal, your agent, if you're principal and you want your agent to make healthcare decisions for you, you have to explicitly say so. And so it'd be the plaintiff's position that those two statutes should be read together in that way.
What if it's an optional decision? I mean, you don't have to agree to it. I guess you do have to make the decision one way or another whether you're going to agree, but you don't have to. There's not one answer that is required. How does that impact the analysis, if at all?
The plaintiff's position is that's not really the distinguishing factor.
More the subject matter.
It's more that this was made in the context. It's the context of the healthcare admission. Yes, Your Honor. I want to turn to the second issue, which is that wrongful death beneficiaries are not bound by the agreement. This is a novel issue. It's a matter of first impression. And so remember here, it was Ms. Sams who signed the arbitration agreement, not the plaintiff. And it is longstanding law in Tennessee and under this court's decision in Harvey that an arbitration agreement is not binding on one who is not party to it. Now, notwithstanding that general rule, the defendants rely on Wood, which is a Western District Tennessee federal decision. And that decision was born out of Tennessee's hybrid wrongful death statute. So there are purely survival statutes that allow others to bring claims on behalf of a decedent, and then there are purely wrongful death statutes that create an entire new cause of action. Tennessee's is both. So following Wood, this court interpreted section 20-5-106A. And that case was an odd case about a plaintiff who was acting pro se and bringing an action on behalf of the wrongful death beneficiaries. And in that case, this court decided that the statute's plain language indicates that in a wrongful death lawsuit, the surviving spouse asserts his own right of action for his own benefit and for the benefit of the other statutory beneficiaries who share in that recovery. And that's from the Beard decision in 2017.
But under Beard, the decedent's cause of action passes then to the representative. And so how does that cause of action not pass with all of the burdens associated with that cause of action? If the decedent had been, had signed an arbitration agreement, and let's say that that the arbitration agreement was effectively entered into by someone who was authorized to do so. That's the same as the decedent agreeing to it. How does, if the cause of action then passes after that person's death, how does it not pass also with all the burdens or the benefits, whatever you consider an arbitration agreement to be, but it passes with both the benefits and the burdens, doesn't it? I'm having trouble following how the arbitration agreement, poof, goes away when that passes.
Your Honor, the key word is the cause of action, right? The cause of action is what passes. This is a contract that was entered into about venue for claims. It does not, under this court's jurisprudence, affect the rights and duties of the parties. The Court of Appeals in T.R. Mills Contractors, Inc. versus WRH Enterprises, LLC, that was a 2002 decision, and it actually cited to, and I'm going to get the pronunciation awfully wrong, Burazinski. In that case, the court went into pretty good detail about how arbitration agreements are merely an agreement as to venue. They do not affect the rights and duties of the parties. And so to answer your question, it's just not part of the claim. The claim would be the injury itself, what occurred from that injury, and then importantly, the wrongful death beneficiaries have damages to which they're entitled that do not accrue until after the decedent has passed. So in a wrongful death situation, we cannot just be concerned about the decedent's rights. We also have to be concerned about the beneficiary's rights because they have rights in this action too. But the way that Tennessee's statute is written and interpreted is that it's this one indivisible cause of action. And so the plaintiff's position is the best way to make sure that everybody's rights are accounted for are to allow the plaintiffs to bring their action in court because they were not parties to the arbitration agreement. Those are basic contract principles. And under all of the jurisprudence interpreting the FAA, those contract principles apply to arbitration agreements just as they would any other agreement. And the U.S. Supreme Court in Morgan, in just this last year, said a court may not devise novel rules to favor arbitration over litigation. And so respectfully, treating this arbitration agreement, especially because it's in the wrongful death context, would be placing that arbitration agreement on different footing from other contracts. Because one of the most basic defenses in contract law in Tennessee is that if you're not a party to a contract, then you're not a party to a contract and you're not bound by it. And Your Honor, it's also important to note that if you look at the case law that the parties have cited, so in Oklahoma, the claim is designed to benefit the heirs. The heirs bring suit on their own behalf. It's a wholly separate scheme. And there, the heirs are not bound by the victim's agreement to arbitrate. And that's the Bowler case from 2014. In Texas, the claim belongs solely to the victim, and the heirs bring suit on the estate's behalf. And you might have heard Ms. Kreider earlier say that this case was brought on the estate's behalf. It was not. It was brought on behalf of the next of kin and the wrongful death beneficiaries. That is an important distinction. In Texas, the heirs bring the lawsuit on the estate's behalf. And so in Ray Labatt Food Service, which is a Texas case from 2009, the Supreme Court determined that heirs are bound by the victim's agreement to arbitrate, which makes sense because it's the estate that's recovering, right? Tennessee's wrongful death statute is a hybrid because the decedent's claim survives and then passes to the next of kin, but then again, the heirs also have this right to claim their own damages that don't accrue until death. So what makes Tennessee's scheme different from Texas's is that Tennessee's wrongful death statute provides for one indivisible claim, and crucially, the proceeds do not go to the decedent's estate. They go directly to the heirs. They bypass the estate completely. The creditors are out of luck. And had it been the legislature's priority to ensure that the decedent fulfilled all of his contractual duties, it would have made more sense to direct the proceeds of that wrongful death action to the estate. And that's just not what the legislature decided to do. Instead, the legislature went the extra mile to ensure that the survivors of wrongful death receive justice. Illinois' wrongful death scheme is most like Tennessee's. The action passes to the decedent's next of kin. The heirs get to claim damages that don't accrue until death. The proceeds bypass the estate and go to the heirs. And under Carter, which is a 2003 Illinois case, the heirs are not bound by the victim's agreement to arbitrate. The defendants have cited a couple of cases that are distinguishable here. Ballard, which is a Michigan case in 1982, their state law dictates that contracts can the contracts binding the decedent also bind the estate, like in Tennessee. But in Michigan, the wrongful death action must be brought by the estate. In Allen...
Counsel, can I interrupt you there? I'm wondering, and I think this may have been addressed in the briefs, but so how are claim releases treated in this context? So if Ms. Sams had agreed as part of admission to the facility to simply waive any current or future claims against the facility, would the heirs then be bound by that?
Yes, Your Honor, and because of...
And why? So why should we treat arbitration agreements differently?
Because by its nature, a release of claims affects the right and duties of the party. And if those rights were waived before the decedent passed, then nothing else can accrue, because that claim, that original claim has already been extinguished. So it's a different situation from an arbitration agreement where we're merely saying this is where this claim should be litigated. It's a very different situation, and it's not, of course...
So if there were simply a forum selection clause, a more traditional kind of forum selection clause in the contract in the agreement with the facility that said, all claims will be litigated in the Middle District of Tennessee, your position would be that would not bind the next of kin in a wrongful death claim?
We don't have those facts here, and certainly that would be another question for another day, but it could or it couldn't. It depends on what the circumstances of that agreement were, I think. I think it would be a very factual question. Here, though, the defendants, they cite this 100 years of precedent, but our courts have consistently held that arbitration agreements do not affect the rights and duties of the parties. They simply shift the forum, and, instead of, the plaintiff doesn't dispute that he's bound by a release that extinguishes the claim completely before death. The plaintiff doesn't dispute that he's bound by applicable laws like statutes of limitation, like tolling, like comparative fault. But this is a contractual matter, and what matters is who the contract is between. And it was between the decedent and the facility, not Mr. Williams, certainly, and not Ms. Sams. And so, as for the defendant's arguments, the defendants cite Benton, which is a Tennessee Supreme Court case from 2004 that deals with this person who was bound by an arbitration agreement. However, that was a contract matter, and that person was a third-party beneficiary who is trying to enforce the underlying contract. And so in the state of Tennessee, when a party who is a third-party beneficiary to a contract wants to enforce the contract, then they're also bound by things like agreements to arbitrate. But those facts are not present here. In the Tennessee Medical Association case, which is a Court of Appeals case from 2017, that dealt with a membership organization. So like a labor union and their members. If the members are bound by an agreement, then the labor union is too. We don't have that kind of representative capacity because of this court's decision in Beard. This case isn't brought in a representative capacity. It's brought on behalf of the wrongful death beneficiaries and to benefit them. And as for the cases that the defendants cite, Burezinski, all those other cases that were Philpott deferred to arbitration without the court addressing this issue, this court knows that you don't make our arguments for us, and that issue was not raised in those cases, so it wasn't decided. So this is a matter of first impression, and ignoring the rule that a party to a contract is not bound would be creating one of those novel rules under Morgan versus Sundance. And so it's the plaintiff's position that the trial court got this right, the Court of Appeals got this right. These were very well-reasoned decisions based on this court's well-reasoned decision in Owens. This court has never held that the reverse of Owens can be true. This court has never held that a person with legal durable power of attorney can make a healthcare decision, and the reverse should not be true today either. And it's for these reasons that the plaintiff asked the court to affirm the decision of the trial court and the Court of Appeals. Thank you.
Thank you, Ms. Martin. Ms. Crider, would you address her last argument first about the whether or not beneficiaries are bound by the arbitration agreement?
Yes,
you didn't get
thank
a chance
you.
to do that last
Thank you,
time.
Justice Page. Ms. Martin, who's an excellent advocate, pointed this court to the case of Burezinski. And Burezinski directly made comment on the issue that is before this court today, and that is whether the wrongful death beneficiaries of a plaintiff who is sued for medical malpractice in that case will be bound to the arbitration agreement that was entered into between the patient and the healthcare provider. And specifically in 1996 in Burezinski, they had the same situation there, which was that the decedent had contracted in the arbitration agreement itself that it was the wishes of the decedent that the heirs and beneficiaries be bound to the arbitration agreement as well, which is what Mr. Williams' arbitration agreement included. And this court specifically made comment about that in its opinion when it wrote, it first acknowledged the language that the decedent had included in the arbitration agreement that they wanted beneficiaries bound, and then it said, other courts have upheld the binding effect of arbitration agreements on spouses and heirs. And then it specifically cited in footnote 4 to the case of Herbert versus Superior Court from California in 1985, which held that determining it is illogical not to subject the wrongful death beneficiary to the arbitration agreement because, and I quote, it is obviously unrealistic to require signatures of all the heirs since they are not even identified at the time of death. And then this court went on to say that that is not unconscionable, oppressive, or outside the reasonable expectations of the parties. So this court has made comment on this very decision it is making today before in the Borozinski decision. And then working backwards from that, I would like to get to Justice Campbell's question about the Venn diagram, which is whether there is ever a part in the middle that is both. In Owens, the court said that decision in that case, that mandatory arbitration agreement, was in that hybrid piece in the middle where those two circles cross. Your Honor, getting to Justice Page, your question, Chief Justice Page's question about what about independent senior living? What about when that progresses to assisted and you might need your medications laid out? At what point does it cross that line? And that was the very concern that this court addressed in Owens when it said we should not start walking down this path because the line is not clear. And then I would like to get to Justice Lee's question about the Kindred case. And in that, the plaintiffs argued that stripping the agency away through a state law rule was what itself violated the Arbitration Act. That can be, the court has said, either a covert stripping or a direct stripping. And in this case, it's more of a direct stripping. And back to your comment, Justice Kirby, that was not a stripping that was done by the legislature. It's perfectly fine to have a provision in a statute that says, if you're going to give someone the right to make a healthcare decision, you've got to specifically give them the right to make a healthcare decision. The stripping would come in taking what is at its heart a legal decision and applying on top of that a requirement that it can only be made by a healthcare decision maker. And finally, I would like to get to the point that Ms. Martin made, that Court of Appeals have not extended this for the reverse to be true, which is that a legal decision maker can also make this arbitration agreement decision. And in the cases of Necessary versus Life Care and Watson versus Quince, the relative of the patient was there to help admit them to the nursing home, and the resident said to the relative, please go take care of my paperwork. It was verbal authority only. And the courts of appeal had to decide whether that verbal authority to go sign the paperwork was going to be enough. And in both of those cases, citing to this opinion in Owens of increasing access to health care and removing uncertainty, the courts found that they could. And back, Justice Kirby, to your point, the legislature mandated that if you're making a health care decision, that has to be in writing and that has to be signed. And necessarily by our courts of appeals finding that verbal authority was enough, they were interpreting that as a legal decision. Thank you so much.
Thank you both for these excellent arguments. We're going to take a short break. Representative Powers, we're not holding you hostage. We'd love for you to stay for the next case, but you're not required to.
Thank you.
Thank you.
All rise. Someone, of course, now in recess.